Norway just handed Jehovah's Witnesses a verdict that has already sent shockwaves through every ex-member who has ever heard the phrase, "We love you, but only if you obey." This was never just about money. It was about whether a modern democratic state can look at a religious organization's internal discipline system and say, no, not this way, not to the children, not to the families, not with public funds attached. Reminiscent of what Japan just did. There's a moment, and I think everyone who has ever left the Jehovah's Witnesses knows this moment, when you first realize that the organization is not what it claimed to be. And for some of you, it was a conversation, a question that didn't get an answer, a punishment that didn't fit the offense. For others, it was the phone call that never came after you were disfellowshipped. The silence from your mother, the way your best friend of 20 years walked past you in a parking lot like you were a lamppost. And today we are talking about a government that dared to say, we see what you are doing to people, we see what you are doing to children, and we are not going to fund it. We are talking about a legal fight that has gone on for over 4 years. District Court, Court of Appeal, and finally the Supreme Court of Norway. And now we have a verdict. So stay with me, this one matters. Now, before we get into the case, let me say this plainly. I'm a former Jehovah's Witness. I grew up in this organization. I knocked on doors. I skipped birthdays. I did not vote. I believed, truly, completely believed that I was one of Jehovah's people, living in the last days, waiting for Armageddon. And then I started asking questions. And the moment I started asking questions, I began to understand what this organization does to people who don't fall in line. Shunning, disfellowshipping, removing unrepentant wrongdoers from the congregation, as the Watchtower prefers to call it now. The organization will tell you it's a loving arrangement. They will tell you it's Bible-based. They will stand in court, and they did stand in court, and tell a panel of judges that family ties are not broken. I want you to sit with that for a moment. They said out loud in a courtroom under oath that family ties are not broken by disfellowshipping. Tell that to the daughter who hasn't spoken to her parents in a decade. Tell that to the teenager who got baptized at 15 and then left at 18 and lost every friend they ever known overnight. Tell that to the man who stood outside a Kingdom Hall in the rain hoping his brother would look at him. Just look at him. Family ties are not broken. That is the lie at the center of this case. Now let me walk you through this from the beginning, because the history of this case is important. You need to understand why before you can appreciate the what. In 2021, the investigation begins. It starts, as it often does, with a single person willing to speak up. In early 2021, a former Jehovah's Witness contacted Norway's Ministry of Children and Families and laid out in detail what the Watchtower's shunning policy actually looks like in practice. Not as described in a carefully worded press release, not as explained by a Watchtower lawyer, but as lived by real human beings. That letter was forwarded to the state administrator of Oslo with a question: is this worth investigating? And the answer was yes. The state administrator opened an investigation. They contacted the Jehovah's Witnesses organization. They asked questions. They shared allegations from former members. They gave the organization every opportunity to respond, to explain, to provide context. And then in January 2022, the first decision happened. After a thorough investigation, the state administrator concluded that the Jehovah's Witnesses violated the human rights of their members through their shunning policy. The consequence? Denial of approximately $1.5 in annual state subsidies, funding that had been flowing peacefully to the organization for 30 years. The witnesses also lost their official status as a registered religious community in Norway. This was not a minor inconvenience. Without registration, they could not solemnize marriages. They could not access rights and privileges extended to over 700 other registered religious communities in Norway. They were, in the eyes of the state, operating outside the law. Now, and I want to be fair here, I want you to understand what Norwegian law actually says. Norway's Religious Communities Act includes a provision stating that no one may be legally bound to belong to or not to belong to a religious community. The concern of the state administrator was direct. The witnesses' shunning policy made leaving the organization so costly, so devastating, that it effectively bound people through fear, not through theology, through terror of social annihilation. So from 2022 to 2024, the legal battle begins. The witnesses appealed. Of course they did. The Watchtower Bible and Tract Society did not spend a century and a half building a global organization to let a Scandinavian government shut off their funding without a fight. The appeal was denied by the ministry. The organization filed suit in December 2022. In March 2024, the Oslo District Court sided with the government, upholding the decision to deny funding and registration. Let me be specific about what that court found. The district court determined that the witnesses' exclusion practices created a coercive social environment that inhibited members' freedom to leave the organization. The word shunning was contested. The organization hates that word, but the reality it describes was not. In 2025, the Court of Appeal reverses everything. Here's where it gets complicated. Here's where I need you to pay attention. In early 2025, the Bogarting Court of Appeal heard the case over a 9-day period. Former members, 9 of them, took the stand and gave personal testimony about what shunning had cost them. Real people, real losses. And on March the 14th, 2025, the Court of Appeal issued its verdict. The witnesses won. 3 judges unanimously reversed the district court's ruling. They determined that the government's decision to revoke registration and deny subsidies was invalid. They awarded the witnesses 8.5 million Norwegian kroner, roughly about 800,000 US dollars, in legal costs. Now, I need to be honest with you about this, even though it stings. The Court of Appeal's reasoning was nuanced. They were hesitant to conclude that group shunning rises to the legal threshold of psychological violence, negative social control, or undue influence as defined under Norwegian law. They called for more data, more documentation, more professional expertise on the mental health consequences of shunning. They were not saying shunning doesn't harm people. They were saying the evidence presented did not meet the legal bar they needed to rule against the practice under the specific framework of the Religious Communities Act. There is a difference between something being wrong and something being illegal, and courts deal with illegality. The government appealed. August 2025, the Supreme Court accepts the case, and in that month, Norway's Supreme Court agreed to hear the case. This is the highest court in Norway. There is no appeal after this. Whatever they decide within Norway is final. So in February 2026, the world watched, and I do not use that phrase lightly. The Supreme Court of Norway live streamed the proceedings. Former Jehovah's Witnesses from around the world logged in to watch. The ex-JW community on Reddit, on YouTube, and social media had been building momentum around this case for years. Tens of thousands of people were following it. The line to get inside the Supreme Court building stretched out the door. 5 Supreme Court justices presided over 3 days of proceedings. The Norwegian state's legal team made a precise and important argument. Religious freedom in Norway, they said, is genuinely and firmly protected. The Constitution does not allow the state to interfere with what a religion believes or teaches. But, and this is crucial, religious freedom does not guarantee public funding. It does not mean every religious organization is entitled to state subsidies regardless of its internal practices. The state's argument rested on a key distinction. Section 16 of the Norwegian Constitution, which calls for all religious and philosophical communities to be supported on an equal footing, does not mean unconditional support. It means equal conditions for evaluation. A community can be assessed against human rights standards as a condition of receiving taxpayer money. The state also submitted something remarkable to the court. A video produced by the Watchtower organization itself, titled, and I want you to note the word choice, "Loyally uphold Jehovah's judgments, shun unrepentant wrongdoers."
They loved me and wanted me to come back to Jehovah. I tried to contact them. I just wanted to talk and to hear their voice. I missed being with my family. And they thought about reaching out to me. But they knew that if they had associated with me, even a little, just to check on me, that small dose of association might have satisfied me. It could have made me think that there was no need to return to Jehovah.
That video had been deleted from the Watchtower's website, but it had been played in court before. The word shun, which the organization's lawyer claimed they never used, appeared in their own title. The Watchtower's lawyer apparently found this moment somewhat humorous. He told the court the word avoid is neutral, that not associating is far removed from shunning. I want to say something about that framing. When an organization titles a video, "Shun unrepentant wrongdoers," and then sends a lawyer to a Supreme Court to argue that they don't use the concept of shunning, that is not a legal technicality. That is institutional dishonesty on a grand scale. The Watchtower lawyer's defense was layered. He argued that 1. Jehovah's Witnesses' practices are protected religious expressions under Article 9 of the European Convention on Human Rights, which guarantees freedom of thought, conscience, and religion. 2, the European Court of Human Rights has previously ruled in cases involving Russia that claims of widespread family harm from Jehovah's Witness membership were not substantiated. He leaned heavily on this precedent. And 3, witnesses who testified before the Court of Appeal about the effects of shunning represented isolated cases, not a systemic pattern. And 4, children are not coerced into baptism. Parents are involved, and young people choose for themselves. Now let me address that last point, because I find it the most dishonest. A child who has grown up in a witness household, who has been told since birth that this is God's organization, that leaving means spiritual death, that associating with worldly people is dangerous, that child is not making a free, informed, unconstrained choice when they get baptized at 15. The organization creates the environment. The organization teaches the doctrine. The organization enforces the consequences. And then the organization's lawyer stands in a court and says the child chose freely. That is not religious freedom. That is institutional engineering of belief. The 5 Supreme Court justices were focused on specific legal questions. 1, how should Norway's religious communities act? Section 6 be interpreted. 2, can a state deny funding to a religious organization based on its internal practices without violating Article 9 of the European Convention? 3, what is the legal threshold for negative social control and psychological violence under Norwegian law? And 4, does the witnesses' shunning policy constitute a violation of individual members' right to freely exit the organization? These are hard questions, Good questions. And the fact that they are being asked at the highest judicial level in Norway is, regardless of the outcome, a significant moment. And then the verdict came. Now, I'm not going to read the entire verdict here. That is in the public domain and can be researched online. But here is what it said. The Supreme Court drew a distinction between moral objection and legal proof on the children's rights issue. The court unanimously found that the state had not presented enough evidence to prove that Jehovah's Witnesses in practice subject minor members to psychological violence or negative social control severe enough to violate legal protected rights. That is a major point, and it should be said fairly. The court did not say the state was foolish, hysterical, or acting in bad faith. It said the evidence was insufficient. In the legal setting, the distinction matters a lot. The court also held that Jehovah's Witnesses satisfy the legal requirement of free and unconditional withdrawal from the religion under Section 2 of the Religious Communities Act. The majority further found that the practice of exclusion did not create undue pressure in violation of Article 9 of the European Convention on Human Rights. The majority relied on several points. The practice is part of the religion's teaching. Members know about it when they join. It does not involve direct coercion or threats, and family ties are not broken for household members or for family members outside the household. That is the legal reasoning. However, two judges dissented, and their reasoning deserves attention. They emphasized that expulsion can lead to loss of contact with family members, especially minors, and that this is not some accidental side effect, but a structured consequence built into the system. That dissent cuts closer to the bone because it recognizes what many former Jehovah's Witnesses already know. The punishment is not just theological, it is social exile. It is the weaponization of belonging. The minority also concluded that the refusal of registration interfered with freedom of religion, but that the interference was justified. In other words, they believed the state could lawfully step in. Now that split tells you something important. Even among highly trained jurists, there was no absolute consensus that this organization's internal discipline is harmless or beyond state scrutiny. So the court sided with the witnesses. But this case has also revealed something that no court ruling can undo. The world is watching. Thousands of survivors have spoken. The video titled "Shun Unrepentant Wrongdoers" was played in the Supreme Court. The organization's own words were entered into the record of the highest legal body in Norway. You cannot unring that bell. And there is one more possible outcome here: a nuanced ruling, a partial clarification, a decision that says the how of what the government did was flawed, but the why was legitimate. And here is how the law should be applied going forward. That kind of ruling can look like a loss in the headlines while containing the seeds of the future accountability. Watchtower will spin whichever outcome they get as a divine vindication. They always do. The governing body will send a letter to the branches, and by the next month's broadcast, whoever is currently sitting in those chairs in Warwick will be telling congregations that Jehovah's hand was clearly visible in the outcome. And I want to step back for a moment and talk about what is actually at stake here. Beyond the funding, beyond the legal precedent, 9 survivors gave personal testimony in the Court of Appeal. 9 human beings sat in front of judges and described what shunning had cost them, their families, their identities, their mental health, their sense of self. The testimony is in the court record. It cannot be expunged. And for thousands of former Jehovah's Witnesses who watched this case unfold, that testimony was validating in a way that is hard to put into words. Because one of the cruelest things about shunning is the gaslighting that accompanies it. The organization tells you the practice is loving. It tells you that if shunning hurts It's because you are spiritually weak. It tells you that the pain you feel is your own fault. To have a court, even a court that ruled against them, acknowledge the pain, acknowledge that 9 people's experiences are real and worthy of legal attention, that is not nothing. The issue of minors baptized as Jehovah's Witnesses, it's, in my view, the most serious dimension of this entire case. Here's the simple reality. A child can be baptized as a Jehovah's Witness before the age of 18. The organization has modified some of its guidance around this in recent years. They have, in fact, eased some disciplinary rules for youth members after serious wrongdoing, which is an interesting, quiet acknowledgement that the old approach was indefensible, but the fundamental structure remains. A child can make a lifelong commitment to an organization with severe social consequences for leaving before they are old enough to vote, to drive, or sign a legal contract. If that child later has doubts, if they leave, if they are disfellowshipped as a teenager, they lose everything: their community, and in many cases their family, their entire social infrastructure. The Norwegian state saw this. The state administrator flagged it. The district court flagged it. The Court of Appeal was hesitant, but it flagged it. The conversation is happening at the highest levels of the legal system of a sovereign democratic nation. People are asking the question, what are we doing to the children? The trend across Scandinavia and potentially across Europe more broadly is toward greater state scrutiny of religious organizations that receive public funding but impose significant social penalties on their own members. The Watchtower is watching this. They know it. And their legal strategy, their armies of expensive lawyers, their carefully crafted public statements, their habit of deleting videos that don't serve them, that entire apparatus exists because they understand that what is happening in Norway is not isolated. This is a continent-level conversation now. The Norway case is not about hating Jehovah's Witnesses. It is not about the government trying to destroy their faith. It is not persecution. It is about whether an organization that receives public money from taxpayers should be allowed to use the threat of total social destruction to keep its members from leaving. And I want to ask you, what does it say about a religion that needs that kind of leverage? If Jehovah's Witnesses represent the truth, if the organization is genuinely guided by God's Spirit, why does leaving have to cost you everything? Why does someone who simply stops believing have to lose their parents, their siblings, their children, their friends? Is that love or is that control? The Norway case is historic. Whatever the Supreme Court ruled, the world has seen inside the Watchtower's legal strategy. The world has heard 9 survivors' testimony. The world has read the title of a video the organization wanted to forget: Shun Unrepentant Wrongdoers. That's what they said. That's what they do. And now, judges at the highest court in Norway have had to grapple with whether a democracy should fund it. The exposure of what this organization does to people is in many ways more important than any single legal outcome. Thank you for watching. If this video helped you understand what is happening, if it validated something you've experienced, or if it answered questions you've had, please consider sharing it. Like and subscribe, and drop a comment below. I'll see you in the next one.